Hello everyone, welcome to Courts Today by Live Law, your go-to source for the latest and fastest legal updates. I'm your host Urvashi Chauhan, here to bring you daily developments, landmark judgments and significant rulings from the world of law. Let us begin with the headlines of the top stories, and after that we will delve into the full details. The Bombay High Court has today struck down the amendment to IT Rules 2023 as unconstitutional. The Supreme Court has taken suo motu cognizance of controversial remarks of a Karnataka High Court judge and sought report from the registry. The top court has allowed all final year law students to appear in the All India Bar Exam 2024. In the UPSC Aspirants death case, the top court has asked Centre to examine coaching centres' issues on pan-India basis. In a concerning development, the Supreme Court's YouTube channel got hacked today. The top court has questioned the Attorney General as to why candidates reiterated by Collegium are not appointed as judges. The Supreme Court expressed its displeasure over the last-minute changes in the NEET-PG 2024 exam pattern by the National Board of Education. The top court, while accepting apology of Telangana Chief Minister Revanth Reddy, has cautioned him to be careful while commenting on court orders. BJP leader Menaka Gandhi has approached the Supreme Court challenging Section 81 of Representation of People's Act. The Supreme Court has slammed the CBI for making scandalous allegations against all courts in West Bengal. The Supreme Court has ordered CBI to investigate a fake petition filed without the petitioner's knowledge before the top court. In a significant update, the tiebreaker judge of the Bombay High Court today struck down the 2023 amendments to the IT rules, which empowers the central government to establish fact-check units to identify fake and misleading information about its businesses on social media platforms. Social media intermediaries like X, Instagram and Facebook would either have to take down the content or add a disclaimer once the government's FCU would have identified the content on their platform the amended rules mandated. The petitioners argued that the two rules are ultra-vires to Section 79 of the IT Act, which protects intermediaries from liability for third-party content. Additionally, they contended that the rules violate fundamental rights, including equal protection under Article 14 and freedom of speech and expression under the Constitution. A division bench of Justices Gautam Patel and Dr. Neena Gokhale delivered a split judgment in this matter in January 2024. Following this, the Chief Justice had appointed Justice Chandrodkar as the tiebreaker judge to hear the matter and give a final opinion on the petitions. Well, now Justice Chandrodkar has struck down the amendments as violative of Articles 14 and 19 of the Constitution. In the next update, the Supreme Court today took suo motu cognizance of the video clips containing controversial comments made by a judge of the Karnataka High Court during hearings. Recently, two videos of Justice V. Srishananda of the High Court surfaced on social media in which he was seen making objectionable remarks. In one video, he was seen referring to an area in Bangalore as Pakistan, and in another video, he was seen making objectionable remarks to a woman advocate. Several social media users, including prominent lawyers, criticized the High Court judge for his remarks, which were live-streamed. A five-judge bench comprising CJI D.Y. Chandrachud and Justices Sanjeev Khanna, B.R. Gawai, Surya Kant and Rishikesh Roy assembled this morning regarding this matter. It directed the Registrar General of the High Court to submit a report after seeking administrative directions from the Chief Justice of Karnataka High Court. The matter will be next considered on Monday. Stay tuned. Coming to an important update for all the law students out there. The Supreme Court has allowed final year law students to appear in the All India Bar Examination, which is scheduled to take place on 24th November. The court passed this interim order while hearing a petition challenging decision of the Bar Council of India to exclude final year law students from registering for the exam. The petitioners submitted that BCI's decision was contrary to the Constitution Bench judgment in Bar Council of India versus Bonifoy Law College and others, as per which final year law students should be allowed to appear in the AIBE. During the hearing today, BCI submitted that they required time to frame rules regarding final year law students. The bench said that they could take time to frame rules but should ensure that final year law students do not lose a year. The bench led by CJI Chandrachud also noted that though this Bonifoy judgment was delivered in February 2023, the BCI is yet to frame rules. While hearing the Motu case arising out of tragic flooding incident at Old Rajendra Nagar, Delhi, in which 3 students lost their lives, the Supreme Court today suggested that the Union of India look at the issue from a pan-India perspective. The matter was before a bench of Justices Surya Kant and Ujjal Bhuya, which made the suggestion to the Attorney General of India, R. Venkataramani, taking into account the latter's submission that a committee has been constituted by the Home Ministry, Government of India, to look into the Delhi incident. The petition was filed by Coaching Federation of India against a Delhi High Court order of December 2023, wherein a slew of directions were issued to effectively regulate the exercise of inspection of all coaching centers. Deeming it frivolous, the petition was dismissed by the top court with a cost of 1 lakh rupees. However, it decided to take suo motu cognizance of the larger issue regarding safety of coaching centers. The court has asked the Union government and Delhi government to demonstrate the safety norms prescribed and the effective mechanism introduced. Justice Surya Kant today pointed out that the incident happened in Delhi, but the issue could arise elsewhere and may eventually need to be addressed across the country on a pan-India basis. The court has told the AG that the committee should address issues from 3 perspectives, that is, legislative, policy, and administrative. In a concerning development, the official YouTube channel of the Supreme Court of India, which is used to live stream court proceedings, was today hacked. Early this morning, the channel's name was altered to Ripple, displaying videos related to cryptocurrency, especially from Ripple Labs, which is a US-based company. As of now, the link to the channel has been disabled. The Supreme Court's registry has acknowledged the breach and is actively working to resolve the situation. In the next update, a bench comprising CJI D.Y. Chandrachud, Justices J.B. Pardewala and Manoj Mishra today heard the PIL, seeking directions to Centre to clear Collegium resolutions in a time-bound manner. A contempt petition filed by the state of Jharkhand against Centre over delay in appointing the Chief Justice of the Jharkhand High Court was also listed today. In July, the Collegium had made recommendations for appointment of Chief Justices of 8 High Courts. As per the judgment in the second judge's case, let me tell you, Collegium reiterations are binding on the Union government. However, these recommendations made in July remain with the government. The Attorney General R. Venkataramani, appearing virtually today, requested for an adjournment. The bench agreed to adjourn the matter by a week, telling Senior Advocate Kapil Sibal, who was appearing for the state of Jharkhand, that the appointments of the Chief Justices are likely to happen in the meantime. The court also asked the Attorney General to give a tabulated chart of the candidates whose names have been reiterated by the Supreme Court Collegium for appointment as judges and give the reasons for not clearing those appointments. The Apex Court today issuing notice in a writ petition seeking measures to ensure increased transparency in NEET-PG exams expressed displeasure over the last-minute changes in the exam pattern by the National Board of Education. The NEET-PG 2024 exam was conducted on 11th August by the board, and the results of which were declared on 23rd August, with the counselling commencing in September. The petitioners have raised issues of lack of transparency and arbitrary last-minute changes in the conduct of the 2024 exam. Senior Advocate Vibha Makhija, appearing for the petitioners, argued that the new marks normalization policy that the board introduced 3 days before the exam was a knee-jerk reaction. She stressed that no regulation are in place by the NBE to ascertain how the exams are to be conducted. Instead, everything is dependent on a single information bulletin which can be modified at the whims and fancies of the authorities. Taking serious note, the Chief Justice of India questioned the counsel for NEB on this, who replied that nothing new or unusual had been done. The bench today issued notice in the matter and directed the NEB and union to file their counter within a week. In another update, a bench comprising Justices B.R. Gavai and K.V. Vishwanathan was today hearing the petition filed by BRS leader G.J. Reddy seeking transfer of the trial of case against Telangana Chief Minister Revanth Reddy over the 2015 cash for votes scam. During an earlier hearing, the court had taken objection to a statement made by Reddy that the bail granted to BRS leader K. Kavitha was part of a deal between the BRS and BJP. The court took umbrage at the suggestion that court passes orders in consultation with political parties. It had rebuked Reddy, saying that it was not a comment expected from a person holding a responsible position. Following that, Reddy expressed unconditional regret and claimed that the comments were taken out of context. Today, while accepting his apology, the court cautioned that care should be exercised while making comments on court's orders, even though fair criticism is welcomed. BJP leader Menaka Gandhi has approached the Supreme Court challenging Section 81 of Representation of People's Act. Gandhi, the former member of parliament from Sultanpur, challenged the election of Nishad, who won by a margin of over 43,000 votes in the 2024 Lok Sabha elections. Gandhi claims that Nishad failed to accurately disclose all the criminal cases pending against him in his nomination form. According to her, while Nishad declared 8 cases, there were actually 12. Earlier, her petition was dismissed by the Allahabad High Court's Lucknow bench as it was filed a week late, violating the 45-day deadline under Section 81 of the Representation of People Act. Although Gandhi had requested the court to excuse the delay due to her hospitalization, her plea was rejected. Now she has taken the matter to the Supreme Court, challenging both Section 81 of the Act and the High Court's decision. The case was listed before a bench of Justices Surya Kant and Ujjal Bhuya. Upon hearing Gandhi's counsel, Senior Advocate Siddharth Luthra, the court asked him to do a comparative analysis of the limitation provisions in context of about 30 special statutes. The matter was posted to 30th September to enable Luthra to place on record the comparative chart. In another development, the Supreme Court today sternly criticized the CBI for making what it called scandalous allegations against courts in West Bengal. The court was hearing a petition by CBI seeking transfer of trial proceedings for post-poll violence cases out of the state, citing a hostile environment in West Bengal's judiciary. The transfer petition, initially filed last December, sought to move cases out of West Bengal, alleging witness intimidation and a threat to justice. The Supreme Court had earlier issued a notice on the petition in February this year. Today, the bench of Justices Abhay S. Oak and Pankaj Mittal strongly condemned the blanket assertion that courts in the state were illegally granting bail and operating in a hostile atmosphere. Justice Oak emphasized that such allegations cast an unfair shadow over the entire judiciary in West Bengal. Following the criticism, Additional Solicitor General S.V. Raju submitted that there were issues with the drafting of the petition and agreed to withdraw it. And lastly, the Supreme Court today ordered CBI to carry out an investigation into a case where the petitioner denied filing any special leave petition and claimed ignorance of advocates who represented him. This is a serious matter and also an interesting one. The facts of this matter relate to the Nitish Katara murder case. Nitish, a Delhi businessman, was murdered in 2002 by one Vikas Yadav, son of politician D.P. Yadav. The trial court had found it to be a case of honor killing and convicted Vikas Yadav, giving him a life sentence in 2008. A person, Ajay Katara, was an important witness in this case. Apparently, the witness was tried to be poisoned on one occasion and he was implicated in as many as 37 criminal cases. In the present case, a girl named Rinki eloped with another person, Sukhpal Singh. Her father filed an FIR against Sukhpal that he had kidnapped his daughter. But Rinki made a statement that she married Sukhpal willingly. But in her statement, she also said that she was raped by Ajay, who met the two of them when they eloped. Ajay is the same person who had testified in the Nitish Katara case. Further, on the allegations of rape, the Allahabad High Court quashed the criminal proceedings against Ajay. An application for recall of this order was filed by Rinki, however, the same was dismissed. Against this dismissal, the present SLP was filed in the name of Rinki's father before the top court. The SLP was first listed on 17th May when notice was issued by a bench of Justices Bela Trivedi and Pankaj Mittal. Thereafter, on 9th July, the petitioner, that is Rinki's father, wrote a letter to the Supreme Court Registry stating that on 3rd July, he was called to a police station in Budan, UP, where he was given notice of the present case and his signatures were obtained on a form. In his letter, the father clarified that he had neither engaged any advocate to file the instant SLP nor signed any wakalatnama or affidavit in that regard. He also claimed that someone else had filed the petition under a conspiracy and sought strict action against such persons. After that, an office report was placed by the registry before the bench where it was mentioned that the petitioner claimed to not have filed the SLP. At the last hearing, when the court was informed by an AOR that he received the petitioner's signed wakalatnama from another advocate and did not witness the petitioner sign it himself, the bench had expressed serious displeasure. The court then asked the notary to appear in the court. The concerned notary entered appearance and admitted the mistake of attesting the petitioner's affidavit in his absence based on identification by his signatures by the advocate who had forwarded it to the AOR. On the other hand, let me tell you, Rinki and her husband Sukhpal stated that they met her father 3-4 months back and he gave them a signed wakalatnama which was given to the advocate. Justice Trivedi came down heavily on advocates on record for their callous approach in practicing before the Supreme Court, especially insofar as filing of wakalatnama and appearing before the court was concerned. The bench noted that the present SLP was filed in an attempt to continue the false case against Ajay Katara. The CBI has been asked to file a formal case after a preliminary inquiry, if needed, against all those who are found involved and responsible. It has been asked to investigate all connections related to the alleged crime and fraud on the court. The CBI director will submit a report to the court within 2 months. Stay tuned. For more details on the cases mentioned here, visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Don't forget to like, share and subscribe to our channel. You can support us by donating through the thanks button at the bottom of our videos or by becoming a member for just 89 rupees per month.